expectancies.
I have just read out that part of the spy tapes when McCarthy is being told that he's the only one who can save us, who can save this country from its madness. Now, I'm going to go to the next part. I know that it uses at some point it uses language that is unpalatable, but I'm quoting the discussions of people. This is how they speak. Page 1524. Now this part, and I will invite the court to go through it at some point because I won't read of it. I'll start at line 92. It's Leonard McCarthy. Says, but I will call you when I'm up there again. At this stage, my flight is on Thursday. I did what you said I should, I must say. You did the right thing, says Bulelani. And Leonard McCarthy says, up until Friday, then I received a strong memorandum to say, charge and charge now. And Bulelani says, Friday. Yeah, no, this Friday. The team says we have been fucking around with this thing. And we are allowing ulterior considerations to play in. And it will become an impossibility later. We must take action and deal with it and finish and clear, as Jackie Silebi said. But that's another story. My lord and my lady, that bit, it's one of the key things that demonstrate that Leonard McCarthy was unlawfully discussing charging with somebody else who's not in the NPA. But there's another thing it tells us. It tells us what he thought of the advice that I said he was given. Charge now. Himself, just like Ncuba.
But this deals with the timing of the charging the
It's the timing.
Yes.
It's the timing. It deals with the timing. And I will argue at the end is that there is no aspect of prosecution that must be decided with a politician. No matter how unimportant we think it is. I'm going to go where they talk about the indictment. Page 1528.
Sorry, Mr. Sirikani, can I just ask, you're reading from this record, there is on the right-hand side, there are comments. Who inserted these comments?
Well, that's why I don't read them, because they...
Yeah, I just wanted to know when we deal with the document as a whole.
Absolutely. The reason I remember, let me explain this document. I'm not a spy, but I think I understand how this works, is that when you have transcripts like this of people who've been recorded, right? You then on the side, because it forms no intelligence until it's really processed in their own cycle. And what you have on the side may be a comment about speculation about what they think. And the reason I'm not reading it to the court that much is because I do not want to burden this court with what I think either an intelligence operative or information analyst was writing, thinking what he was thinking or what she was thinking. So, McCarthy says, and by then Steinberg decided he wants to go home, and the kid wants to start his leave because his mother at the end of her life, and he wanted the last holiday with her. And one of deploy were on leave. And Trengov is on leave. And I sat drafting with one advocate, and we probably finished half of it now. Salmon must look at it. And Trengov said he wants. It's so important. He would like to see it before it goes in, before he must argue the damn thing, which is fair. So we will No, Mr. Trengov didn't say that, and Mr. Trengov was not involved. They were talking about him. But I'm reading this portion because it talks about the indictment at some point. What did you say? Okay.
Is this the indictment or is it the affidavit in
The
the
affidavit that they are drafting.
Yeah.
Okay.
Then it says, can I get a draft? Can you deliver a draft at my place? Where are you now? In Joburg. Okay, I will be back. Leonard says, I thought you said you are starting your leave and you will be there. Yeah, but it's part of my leave. I was actually coming to Cape Town to see you, but no, it's fine. Leonard says, I will rather come myself. I don't want to take chances. No, because I will get there late tonight. Leonard says, no, I'll wait for you and call me when you are here, or I will see you first thing in the morning. Or you come to me, I don't know, but I don't want intermediaries here. Bulelani says, okay, you're right, you're absolutely right. Yeah, you know, Zuma will say we are conspiring against him. Can I ask? And the script has not changed yet. It's a question. I'm making one point here, that I said we must connect the right dots, not the wrong ones. We must connect the right dots about this pattern, that this is being discussed, whatever it is, unlawfully with someone who has no business in the prosecution of Mr. Zuma or anybody. But the next pages of this that I will invite the court to go through, and I want to summarize them because we will be here the whole week if I do. It's a lot of terrible things people are saying. Is that they will demonstrate to you that a president was involved in their discussions. A minister was involved in their discussions. That the timing of the prosecution had nothing to do with prosecutorial functions. That the timing, as you will see if you read the parts I have not read, is that precisely what the NPA has been told time and again by those who care to tell it. They do not have, and they are constitutionally prohibited from taking instructions about aspects of prosecutions and doing their work. So why is this important? Why is all of this important? It's important as I'll get to the cases now, because as we read these cases that deal with the permanent stay, it's a matter we've debated slightly that, well, a delay on its own and time is not enough for you to get a permanent stay. There must be extraordinary circumstances that exist. I want to invite this court to agree with me that when an organ of state as powerful as the NPA, now, in the future or in the past, because it will be us one day, when they discuss with political players about when you must be arrested and how you must be prejudiced by that, and they discuss it with people who have nothing to do with prosecution, our courts, which are the custodians of constitutionalism, must not tolerate it simply because we're dealing with a suspect who may have committed what we don't like. It's the point I am making. The point about this, is that the pattern of behavior is what distinguishes this almost 20-year-old case from the other cases, some of which a stay was granted after a delay of 3 years, like Mr. Phillips and others. But maybe let me just go, and I persist with the arguments we make there and those decisions. I also want to submit to this court that the court must go to those parts of our heads of arguments when we deal with criticism by our courts of the conduct of the NPA in this matter.
So let me just try and understand you on this point, because I think it's important. So are you suggesting that once we find that there was this discussion, we shouldn't look at the integrity of the investigation, whether it was tainted in any way?
No, there is no aspect that I'm inviting the court not to look at.
Yes.
That's the first thing.
So we still have to
You
interrogate
have to
the
look
integrity
at
of the
all
investigation.
of this and consider it. But here is the point I'm trying to make. I am saying, in your attempts to read and find how serious corruption is and all the points you must look at, you are the custodians of how organs of state must act. And whatever you find with all of those things, how serious corruption is, how insignificant the delay is, what is important, and I find that we submit is extraordinary, is what this court says about those who hold power of the state to prosecute others when they tell lies, or when they abuse, or when they connive with people who are outside the state. And it is the court's function to determine whether all the factors, my lord, you say you may want to consider, can ever justify an organ of state granting itself power to act as it wishes, and unconstitutionally and unlawfully as we submit. Well, we have set out those facts. And my lord, I don't want to, I have gone through what we call in our heads the spy tapes. The reason I've not read all of it is exactly as I said. I've concentrated on those parts that really, really demonstrate to you that a discussion about an accused, an instruction was being taken from politicians. And this court must tell us how it views a national director of prosecutions taking instructions from an outsider and linking whatever they want to do to political outcomes. I know that our learned friends like saying, no, but Haram's dealt with that motive issue a long time ago. We're not suggesting, we're not dealing with motive. We're not dealing with that aspect. We're dealing with the fact that an organ of state acted unconstitutionally, violated its own policies, violated the act from which it derives its power, and lastly, violated the Constitution. And this court must tell us if, when it balances it with other things, that unconstitutional conduct can be condoned. Those parts, we insist with them, they are there. I want to go to invite this court, because what I'm saying here is not just the story that Mr. Zuma has told or is telling. I invite this court, without reading this affidavit of Mr. Hofmeyer, because that is the NPA. Mr. Hofmeyer wrote that as the NPA, condemning how they had behaved. I'm inviting this court again to read Mr. Mshe's statement itself, how the NPA had himself, this is the NPA, describe their own conduct. The fact that those who've come later for different motives don't like what he said, the fact that colleagues in the media, insurgent at the bar, call it what they call it, the fact of the matter is the institution itself at different times, those who have a conscience in it, have described their conduct as bad, indefensible, and unlawful themselves. It's not us only.
But, Mr. Sikakane, are we not going to be constrained in some of these criticisms by the findings of the SCA? For instance, in Mr. Hofmeyer, Mr. Mshe's, because they've made various findings in these particular issues. And I don't think we can find otherwise unless there is something that you convince us otherwise if they have found in a particular manner.
Well,
started the cases
yes,
dictate
no,
so.
I understand.
Yes.
I understand. Let's get to that because it's a famous argument from our learned friends as well. Oh, the SCA has said ABCD. Ignore Hofmeyer. The SCA has said ABCD. Let me tell you this, my lady. That affidavit of Mr. Hofmeyer remains something the NPA stated on oath. The comments of the judges about his conduct, and we know he's still there, he's still around, and he's just been promoted, he acted well, so he's a man of integrity, he's there. His affidavit has not been found to be a lie. He has not written an affidavit countering that. I think the comments that I saw in the cases about it, our learned friends pick. They choose what it is that they think he's right by saying and where they think he's wrong. We say this court must consider an affidavit filed by the NPA in a matter on oath before it. And we do not have an affidavit disputing that from Mr. Hofmeyer. Mr. Hofmeyer, that's his affidavit. We say it's consistent with the statement of Mr. Mshe.
But Mr. Sikakane, I think what my sister alluded to is that when we look at the decision of the ACA, the Judge Nafsa criticized the affidavit by Mr. Hofmeyer, and that all appears on pages, I think, 230. And it concludes in paragraph 75 of that judgment. Mr. Hofmeyer was intent on imputing the decision to prosecute Mr. Zuma to Mr. McCarthy. He sought to dispel as untrue the statement made on behalf of the NPA in an affidavit in other litigation that Mashia had made the decision to prosecute. This was done notwithstanding that this court in Zuma had decided on the evidence placed before it that Mr. Mashia had taken the decision to prosecute Mr. Zuma. And then it goes on the criticisms of that. I think, if I understood my sister correctly, is we cannot ignore the findings of the Supreme Court of Appeal regarding that affidavit. Yes. So I think, is there a way that we should ignore this? What would then be your submission regarding the criticisms?
Yes. My lady, the SCA was never faced with the question you are faced with today.
Just on that point, Mr. Sikakane, the SCA has also spoken about the timing of charging. They say the motive is irrelevant.
Yeah, it has even said
Yes,
the motive
yes.
of prosecution is not a problem.
But if you go further than that, if you actually look at Mr. Mshe's statement, in his own statement, he makes a point that he could find nothing wrong with the prosecution team. In other words, there was nothing wrong with the investigation itself. He makes that point. He makes it clear.
Yes.
Yeah.
But, my lord, I don't know whether I had finished the answer.
Yes.
But a lady had answered, is that they were first. Can I start with your question
Yes,
and complete it?
yeah.
They were not faced with the question you must determine. They made comments. They did not say that affidavit. I do not believe that affidavit must be ignored, what is said by this organization on oath must be ignored because the SCA had comments about Mr. Hofmeyer and what he was saying. It remains and they described their conduct on oath in court. The second thing is this, and I invite you to read more in the spy tapes because you will find members of the NPA discussing what to hide from a court. So it's not something I'm taking from nowhere. And I'm saying one of the issues you will have to deal with.
Is it really not a smoking gun that can be cleared by the trial court? That issue about the tapes?
Well, this is the answer I gave earlier then, my lord, is it depends on what you are dealing with. What I've presented to you is what I say are extraordinary violations of the Constitution. And there is nothing that can't be dealt with a trial court. But what I'm submitting to you is that violations of the Constitution in pursuit of even the ugliest criminal we hate cannot be condoned. And I'm saying it is extraordinary to violate a constitution. If you find, this is when I will lose this case. If you find, and you have to find this way to differ with me, is that all of the things that happen, the discussion with politicians in South Africa when I want to charge are fine. If you find that it's not unlawful when I'm prosecuting to do what we say Leonard McCarthy and Bulelani Ngugat did, it's not against the spirit and provisions of our Constitution, I must lose this case. If you find that NPA from today and going forward in pursuit of someone who's accused, they can do what Leonard McCarthy was doing. They can take instructions from the DA and the ANC and everybody in order to time things to suit political players. You are free to take that decision. This court, I must lose this case if this court does not find that violation extraordinary. And I'm adding it because most of those cases tell us how difficult this is. I am saying this court, the three of you, sit here as probably the ultimate custodians of the Constitution. And I will gladly lose the matter if a court tells me that violations of the Constitution of this nature, unjustified, not in terms of Section 6636, which tells us how we can violate them if it's allowed. It's just done. I will gladly accept that I'm wrong. But I am saying it is extraordinary that people can violate a constitution the way they want because they are pursuing someone we dislike and they are pursuing someone they suspect. So it can be decided, my lord, in the trial court, but the court will have to go through what I'm submitting now. Disagree with me on what I've just told you now, and I'll gladly accept your verdict. Then we deal with the cases. I promised my learned friends I'll be done at 3, so that's why I'm rushing. I invite the court to look at all of the findings by Judge Msimang. There is no suggestion that Judge Msimang was wrong in stating the things I have stated. And he hadn't read, may his soul rest in peace, he hadn't even read the spy tapes. Even then, in 2006, he complained bitterly about the conduct of the NPA. Yes, I know Sergeant at the bar doesn't like Nicholson. People say it wasn't, I'm saying I'm inviting this court. Read what he says. in relation to what you must find, you are determining what is before you, because it has never been before anybody. The questions you are dealing with have never been before any court, and you are free to determine it the way you wish without differing with the SCA. Now, what are the cases that should guide you, and what do they say? Where's my notes? Let me start just briefly with the Bosma case. I'm going to briefly tell you what it was about without taking your time. This is in 2010. It's a constitutional court matter. In this case, Mr. Bosma instituted a private prosecution. Mrs. Bosma. It's Mrs. Bosma. Complaining that when she was 13 and 37 years had passed, she was raped or sexually abused by Mr. Thales, a family friend. I think it had been 39 years. And on 21 December, she instituted a private prosecution. She first appeared on the 5th of February, 2008. Just a year, I think, well, less than a year. Then it was remanded to 17 June 2008, the same year. Then, before it was heard, he brought a permanent stay application. And there are two questions that are important in this case for you to determine, because they raise issues about which we can get criticized in this matter. He says after 2-3 years, all the evidence is gone. This was 39 years ago. Now he's talking about the time when the offense was committed, not when the prosecution started. So basically, he is complaining, and he loses this case, because he is complaining that there has been a delay by the state of some 2 years or 3 years, because eventually it was set down in October 2009. He also complained that the offense occurred a long time ago, as if that makes any difference in terms of its nature. But of course he was criticized because he talks about the time of his offense, not the time when the NPA started, when the prosecution started his case. And he loses, of course, because the court says he had to detail the trial prejudice that he complained about. He said people had died, the evidence was no longer there, he couldn't find his diary where he was on the day. And so, how different are we in this case? Well, I have it said to this court, first of all, you have to determine how long this has been. Secondly, you have to determine the fact that we've asked for documents, we don't have them, we don't have a full set up to today. You have to determine the fact that can we ever have a fair trial after such a lapse of time in a matter of this nature, and the type of evidence to be led in a matter of this nature. And lastly, because all of these cases tell you this is extraordinary, you've got to tell us much more. I don't want to harp on the point. There is something extraordinary about constitutional violation, I think. So our case, Mr. Zuma's case, is distinguishable from those cases for a number of reasons. The other one that our learned friend's case, and it's a famous case because judges make telling points, is the Sanderson case. And I know why our learned friends like this case. because it's part of the theory about Mr. Zuma. Mr. Zuma is they say he is the cause of the delay. And the Sanderson case at paragraph 33, I think talks about an accused who is the primary agent of the delay cannot come to court and complain that there has been a delay. It's like someone banning the court and saying, I'm coming for a permanent stay because the court is not available. And the court was right. In cases where the courts have said this, they were right. But I have said in our case, you cannot compare it with these cases. If you look at the facts, you look at what has happened, you look at the violations, you look at who caused which delays. And there were many postponements in that case. I was going to read its passages, but I don't have to. Our learned friends, there is a case as well. It's the Fraser case that I referred to. Because we are lawyers, sometimes we pick cases that say what we want to say. But I think it's important to state all of these cases, including the ones that are not with us. This was a civil case for a start, Fraser case, unlike what we are dealing with here. The appellant was an awaiting trial prisoner who had been indicted on several counts related to racketeering and money laundering. So it's a different matter altogether. And he was charged in terms of poker. So a provisional restraint under Section 26 of poker was obtained against him, against his interest in a closed corporation and his other properties. So that's the nature of that case. But what does he do? This is the man they accuse later, as I will say, that he participated in wrongdoing that led to the delay. Because basically ABSA gets involved in this matter because it was one of Fraser's concurrent creditors who had obtained a default judgment against him. And they sought to intervene. Right, they lost, but then their case was dismissed. And then in the SCA, ABSA's appeal was upheld. Fraser approached the Concord now to appeal against the SCA on the ground that its decision will result in unreasonable delay. And of course he lost, and he should have lost. Because as they said there, he had been involved himself in trying to conceal his property, his assets. So all of this case, I invite this court to go to the Phillips case versus the DPP, because in that one, it was granted. I invite this court, without wasting its time, to go to the Van Heerden case and look at it. I invite you to read the others and see that the golden thread that runs through them is that while these courts tell us that this is an extraordinary remedy, they tell us that when the fairness of the trial in terms of Section 35(3)(d) has been severely compromised or affected, you can't say you will not grant if that is demonstrated. The others tell us, as your ladyship was saying, the delay on its own is not enough, but show something else. And they tell us that, of course, because it's extraordinary, what exceptional circumstances exist? Now, I know that exceptional sounds like something spectacular must happen. I'm inviting this court to look at whether, if they find, as I say, an organ of state acting unconstitutionally, acting unlawfully in pursuit of a citizen, is not spectacular in a modern democracy, in a constitutional state. I'm inviting this court to tell me and us that it's not spectacular to act that way. And the submission I am making is that even if we are weak on every point, even if Mr. Zuma postponed all the matters himself in the past 15 years because he's a Stalinist, it is exceptional. It is exceptional that constitutional violations happen by an organ of state whose power is one of the most serious because it can limit our liberties. Those are the cases I invite this court to look at. And those are the cases on the basis of which the issues I have raised, my lord and my ladies, is that you will find that when you read some of the things I have not read in the spy tapes and the violations that I put before you, when you look at whether or not, even if Mr. Zuma may have contributed to some delay by going to court, because we told that even approaching a court by him is a delay, doing the right thing, not discussing his case with a politician, going to court, making representations. He's responsible. You will find no occasion in these 5,000 pages before you when the postponement was because of him. Yes, he may have wanted to make representations, but that is an exercise of his right as a litigant where he feels that his rights were violated. Those, if you find against us on all of the issues about the delay, and if you think they must be juxtaposed with everything else, I want to invite you to look at those cases and tell us and make a decision that the violations which are common cause of the supreme law of the land do not constitute exceptional circumstances. I'm inviting this court to write any judgment. I'm not desperate to win this case. I'm desperate to hear how organs of state and myself and everyone must behave between now and the future about the Constitution. I want to hear this court tell me that acting unconstitutionally is not exceptional. Those are the issues we say, even if we are wrong, which we dispute, because the delay, the social stigma. When I say in the heads, Mr. Zuma is synonymous with corruption now, it's something we write, as I said. We have to think back to that social stigma, whether we would like it unto ourselves. A social stigma you carry as a family man for being accused. And that stigma, I'm inviting you to look at it in a constitutional democracy as an exceptional occurrence that violates the values that we call supreme.
On that point, can I ask this question, Mr. Sikhakhane? As I understand the argument and the papers, that stigma started way back 2000 or 2003, and it's carrying on. This application does not go into the merits of the case. If we were to grant it, it leaves that stigma standing. When will it ever be cleared? Or will it ever be cleared? Because I think it's on record on several occasions that Mr. Zuma said he wanted to clear his name. So in a balancing act, how will that ever happen?
It's an important question, my lady. And let me deal with it in three parts. Because the question you ask is, why doesn't he go to court? A lot of people think I should just walk Mr. Zuma to Mampuru prison or Westville, because...
No, but that's not my question.
No, I'm saying that's my introduction to the court.
You started it on a wrong footing. You say, why doesn't he just go to court?
Well,
and I don't want it to be misunderstood. I'm
Okay.
saying, how do we balance all of those factors?
You
that
balance it this way. I
Yes.
still ask you to consider that any accused person, whether you make the order now that vindicates him or it's made by the criminal court, my answer to your question, your order condemning unconstitutional conduct towards him will in some way deal with the stigma he has dealt with. He has had to endure. In many other respects, my lady, the insults we hurl at others can never be cured. And in the eyes of many, exactly because of the violations, his name will always be synonymous with something that he has never had the time to deal with. And I'm saying to you, your decision would itself vindicate him. It may leave certain scars about the stigma and all of that, but it will be an important decision because those who violated his rights, for whatever reason, shall have learned a lesson that in pursuit of that person who is accused of murder, they do not have to violate the Constitution. That's all. And I think his rights shall have been protected, and the respect of the Constitution shall have been respected. With those words, I want to end where I started. We started with McCarthy and the investigation. I end with their conduct as well. That this conduct, and by the way, the spy tapes, I can safely say, spy tapes are the tip of the iceberg when you bug people, because it's not all conversations. It's just some of the conversations, right? And so the pattern, you have to make the inference that the pattern of discussing and aligning this prosecution with political purposes had been there. The script that McCarthy was asking about, is the script still, has it changed? Started earlier than the recordings we have. And I invite this court to agree with me that of the two legal philosophies, one, which is mob justice, we will do what we like with the person we suspect, and the other, even if we think you've done the most egregious crime in this modern caring society built on the values of the Constitution, we will deal with you constitutionally, no matter how much people hate you. Those are our submissions. And Mr. Masuku will deal with those aspects of the law that we say by acting in the manner in which the different individuals acted. We invite the court to take note that the NPA Act was violated. That a lot of cases tell us so, both here and in other jurisdictions. The policy of the NPA itself was violated. And largely, what you exist in this room to protect was violated in pursuit of an accused. And we will plead with the court to look at the violations that I've set out as exceptional circumstances that have not happened in post-apartheid South Africa about how we pursue human beings we think have wronged us. Those are our submissions.
Thank you. Yes, thank you.
My lord, my lady, I just, I'm very bad with technology, so yes, I've got it. Thank you. Let me start off where my learned leader left. There are three things I intend to deal with. Firstly, it is why it's important for the court to examine carefully the conduct of the NPA against its own constitutional and legislative basis. And then to ask the question whether or not the conduct which my learned leader has dealt with extensively has fallen way too low or short the constitutional standard that is expected of the NPA. And that takes the courage to understand who the NPA is in our constitutional system. It's not a hyperbole when we submit that the NPA sits at the core of constitutionalism, and it is a very critical institution that is tasked with the rule of law. In other words, the constitutional system would collapse if the NPA were allowed to behave the way in which this NPA has in fact behaved. Just before I crystallize the point, let me put it this way. It is horrifying, and it's heartening to know that there is a court system that is impartial, that is independent, that will engage with the issues in that manner. That you are faced with a litigant who is an organ of state, carrying weighty constitutional responsibilities that have implications for the rights of citizens. That litigant is before you. And before you, that litigant says, yes, there was an MP, they themselves, on their own words, from their own mouths, that they themselves were wrong in the way they've dealt with the Zuma prosecution. They themselves say it. You've got to look at what they say about what is wrong with the way in which they managed the Zuma prosecution. And this takes us to why my learned leader submits that when you sit as a court and you examine the conduct of the NPA, you have to say to yourselves, something was wrong. Because on their own version, take what Hofmeyr says about the NPA and its conduct. Now, I'm not concerned about the fact that the Supreme Court of Appeal said something about that affidavit. It's here. It's before you. That's what the NPA tells you. So the NPA has 2, 3, or 4 affidavits before you. At the moment, there are 2. The one affidavit tells you, this is what we did. It was wrong. It was so wrong that we had to terminate this prosecution. The other affidavit says, no, actually, we want to prosecute. We seriously want to prosecute. And the only basis they are telling you that they want to prosecute is because they say they have evidence against Zuma. But what they have not done, and I'll get back to what our colleague, Mr. Trengrove's address when he gave a public lecture actually says. What they don't say, and this is also what the Supreme Court of Appeal doesn't say, what are the constitutional implications of an NPA that is found to have committed a constitutional error to the rights of the person against whom they've committed that error? So they don't talk at all about the rights of Mr. Zuma. They don't say we found that the NPA has flouted its own laws, it has flouted the Constitution. That's what we have found as a court. But what they don't do is to extend that finding a little bit further and look for what the Constitution requires them to do, which is to look for a just and equitable remedy fitting the size of the constitutional transgression. They don't do that. And that's what the NPA has not done. And let me come back to what my leader said I was going to address. And it's the following. The NPA does not operate in a vacuum. And perhaps a legal statement has to be made in order to underpin how you assess its conduct. How you assess its conduct is very important, because this is what the Constitution says about an institution like the NPA. And you'll find that in the EFF judgment, in which the judgment of Nkandla, that's the judgment I'm referring to. What Chief Justice Mogoeng says there is in reference to the presidency. And he says, in paragraph 1 of that judgment, he says, one of the crucial elements of our constitutional vision is to make a decisive break from the unchecked abuse of state power and resources that was virtually institutionalized during the apartheid era. And this is important because later on when we deal with the striking off application, where we do say that there is the approach of the NPA takes us back there. Because what they are saying to you is, don't worry about the fact that there were constitutional violations. We want to prosecute him. It doesn't matter what we have done. We have the constitutional credibility to ask to prosecute a man whose rights were violated. That's what they're asking you to do. But to achieve this, so Mogoeng says, to achieve this goal of a break, a decisive break from the apartheid thinking, that it doesn't matter the constitutional violations a prosecuting authority has committed, you nonetheless must go to court and answer the criminal charges. That's why these proceedings are very important. So Chief Justice Mogoeng says, to achieve this goal, we adopted accountability, the rule of law, and the supremacy of the Constitution as values of the constitutional democracy. For this reason, public office bearers like the NPA office bearers ignore their constitutional obligations at their peril. This is so because constitutionalism, accountability, and the rule of law constitute the sharp and mighty sword that stands ready to chop the ugly head of impunity of its stiffened neck. It is against this background that the following remarks must be understood. Certain values in the Constitution have been designated as foundational to our democracy. This in turn means that as pillar stone of this democracy, they must be observed scrupulously. That's what the Chief Justice says. If these values are not observed and their precepts not carried out conscientiously, we have a recipe for a constitutional crisis of great magnitude. In a state predicated on a desire to maintain the rule of law, it is imperative that one and all should be driven by a moral obligation to ensure the continued survival of our democracy. And now, why is this very important for us? The NPA is given the highest protection an institution can ever be given: prosecutorial independence. And why are they given that independence? Because they carry out constitutional obligations that require that independence. And in fact, prosecutors, from top to the bottom, they have to take an oath of office that states in unequivocal terms that they will observe the rights of people, which includes dignity. And it's just for the court, for emphasis. The Constitution protects inherent dignity. It's dignity that you're born with. You don't earn it. When an institution as powerful as the NPA violates the dignity of a former president, or a president at the time, or somebody at that level, and they come to court, they say, it doesn't matter that we've done this, because on their own version they accept they've done it. They've violated his rights. They say, no, all that you need to look at is whether a permanent stay of prosecution is a fitting remedy for that constitutional violation. And we say it is a fitting remedy. It is a just and equitable remedy because of why? Because of what the NPA, what binds the NPA. When the NPA appears before this honorable court, they have to, and will probably come back to that principle. The NPA cannot come to this court with dirty hands, with hands dripping of constitutional violations of accused persons, and then say, oh, we demand that we exercise our duty to prosecute. It doesn't matter what we have done. That doctrine that says court will not come to the assistance of a party whose hands are dirty, not in the real sense, but they violated someone's rights. This is our law. It says you do not come to the assistance of a party who comes to you and says, hey, you know what, we have actually violated the law. We've abused this our powers with such gravity that our leaders in the institution, not Downer. Downer is not the leader of the NPA. We are told by the NDPP, in his own words, that the gravity of the violation is such that he cannot, in a clean conscience, take it. He can't stand with constitutional credibility, try and persuade the judges of this country that he has done a good job in prosecuting, in the way the prosecution of Mr. Zuma has been managed. He cannot do that. But here they are. What's and all, they say, with one side of their mouth, we have violated Mr. Zuma's rights. With another, they say, we have not violated Mr. Zuma's rights. How can that be? How can that institution be trusted with this power they have?
Sorry, Mr. Masuku, to interrupt you, but will you perhaps direct us specifically where they make this concession that they have violated Mr. Zuma?
I do no more than refer you to Mr. Hofmeer's own affidavit, to Mshe's affidavit, to Mr. Mshe's confirmatory affidavit, to that affidavit. I do no more than refer you to Mr. Downer's own to Mr. Downer's own position when he advises the NPA constantly that they must prosecute Mr. Zuma.
Yeah, but there's one thing of saying you should you should be prosecuted, but if we say that there is a constitutional violation, and I understand you can accept in our favor that we understand Mr. Sikakani's submissions that he made on that score. But if you say that they acknowledge that they have violated it, you say we must look at the Hofmeer affidavit.
Yes.
Well,
it's not just the Hofmeer's affidavit. You've got to look at the NPS affidavit done by Mr. Hofmeer.
Yes, I know that. But that ultimately it is Mr. Hofmeer that
Yes.
finally made that. So that is the affidavit on behalf of the NPA. But then again, if we do that, then we are back at the square where my sister alluded to. Then we have to also consider what the Supreme Court of Appeal had said about that affidavit.
Respectfully, you don't have to. You don't have to consider what the Supreme Court of Appeal said about this matter. They were not dealing with the permanent stay application.
Not the matter. No. We are here at cross purposes. I'm not saying about the matter. I'm saying what the Supreme Court of Appeal said about Mr. Hofmeer's affidavit.
No, yes, you can have regards to that, but it's an aggravation. You've been told by a Supreme Court of Appeal that this affidavit is just bad. It is so bad. Instead of strengthening the system, instead of strengthening the NPA or strengthening their integrity, it has actually undermined them. What you are being told is that a senior official of the NPA, together with the whole leadership of the NPA, submitted an affidavit that was unbelievably wrong. That's what you're being told. But why should that not be grave concern to a court that has a duty to protect the rights of persons? Or perhaps just a direct answer to your ladyship's question. That is the fact that the Supreme Court of Appeal says what it says about that affidavit tells you a lot. That should weigh heavily when you consider the conduct of the NPA. Essentially what the Supreme Court of Appeal says is that here is an affidavit purporting to tell us what the NPA has done. We don't even trust it. We ourselves think that this affidavit is wrong. That surely must, when you consider whether or not an appropriate remedy, just an equitable remedy, is a permanent stay, you have to look at that statement by the Supreme Court of Appeal as an aggravation, not as an issue that vindicates the NPA's position. It doesn't extricate them from the complexity that they've placed themselves in. It makes it worse, because the court is disowning, is basically saying the NPA has done a bad job. Now, why should you trust that institution to be the one that prosecutes the men against whom this bad behavior has been done? So, as the Honorable Justice, you know that the NPA is established in terms of the Constitution, and it operates in terms of the NPA Act. That's what must guide how you examine the gravity of their offense. And you've got to ask the question, and then if you look at Section 32 of the NPA Act, it provides for the impartiality and an oath or an affirmation by members of the NPA. And this question of impartiality is very important as well, because it must tell you how important the decision-making system or decision-making machinery of the NPA is, because they are not meant to be activists for a particular prosecution or a particular outcome. They, like judges, look at the matter, they, with an open mind, apply themselves to what the issues are, and then they must decide. Section 32(1)(a) provides that a member of the NPA shall serve impartially and carry out his duties and functions in good faith and without fear, favor, or prejudice, and subject only to the Constitution and the law. Section 32(1)(b) provides a very strong imperative against interference with a member of the NPA. It prohibits any state organ or member of the, or any person from improperly interfering with, hindering, obstructing the NPA in the exercise of its duties and functions. To enforce this seriousness of this prohibition on any interference, and this is where we ask ourselves, we know that what McCarthy and Vulalene did was serious interference. But up to today, there's not a single person who's accounted for that. The NPA has never been held to account for that serious transgressions. But here we have a law saying that Section 41 says that if you contravene Section 32, it's such a serious offense that you could be liable for a conviction, you could be liable on conviction to a fine or to imprisonment for a period not exceeding 10 years or both. The prosecution policy of, so you will see that in the NPA Act, there is a requirement that the NTPP, together with the Minister of Justice, and in consultation with the others, that they must have what is known as a prosecution policy. That policy is very important, is a very important instrument for you to assess the conduct of various prosecutors in the case, and to ask the question whether or not they've acted in terms of that policy. The policy states that the decision whether or not to prosecute must be taken with care because it may have profound consequences for victims, witnesses, accused, and their families. A wrong decision may also undermine the community's confidence in the prosecuting system. So once a prosecutor is satisfied that there is sufficient evidence to provide a reasonable prospect of a conviction, a prosecution should normally follow. This is all in the prosecution policy, which I urge the court to have regards to. I urge the court to look at it carefully, because you'll find there that the policy itself says people, and it means everybody, from the top to the bottom up. Everybody should be able to rely on and accept decisions made by members of the NPA. Normally, when a suspect or an accused is informed that there will not be a prosecution or that charges have been withdrawn, that should be the end of the matter. I mean, that's what the policy says. So now, here's the situation we find ourselves in. The one gentleman says, no, we're not going to prosecute. Stars and mars in the public domain through press conferences. The next one says we're going to prosecute. When the prosecution comes to court to run the prosecution, they ask for a postponement, and then they don't prosecute, they're struck off the roll. They're criticized by a judge. The third one says, well, I'm going to prosecute, and then they discover how there's been a violation of, there's been an abuse of the prosecutorial system. And he says, I'm not going to prosecute, I'm going to terminate the prosecution. What is the person, the target of the prosecution supposed to think? What is society supposed to think? That the prosecution can play toys, can play games with people's lives like that? It can't be right. So what we're urging the court to have regards to is the policy that is binding, and that policy is binding in the sense that mandatory terms are used in order in terms. So fundamental to what we submit is that there's been a complete flouting, complete violation of the Constitution itself by the NPA, in that they have not acted in a way that is independent. There's been a complete violation of the NPA Act, in that the decision makers that are involved have not done so in accordance with the provisions of the Act or in accordance with their oath of office. There's been a complete violation of the Code of Conduct and the Prosecution Policy of the NPA Act. So fundamental to the submission that has already been made is that there is in fact a serious breach of constitutional process by the NPA, which can only justify not just a finding that this conduct is unconstitutional, but that the appropriate remedy for that unconstitutional conduct is a permanent stay application. Sorry, is a permanent stay, is an order granting a permanent stay. My lord, my lady, my ladies, this is not just an issue that is concerned South Africa only. In our heads of arguments, we've dealt with what other nations, how other nations have dealt with these sort of matters. I do no more than urge you to look at what we say and the cases that we refer to. But what is important to think very, very carefully about in terms of an appropriate order that is just and equitable is to look at this doctrine that has come through, two doctrines that I would leave with this court's mind. The first one is the doctrine of abuse of process. In other words, if one looks at, as a court, if you look at section 165 of the Constitution, which essentially tells us the qualities of the qualities of our courts. It says that the courts have I beg, I'm looking for the Constitution. But anyway, it basically says that the courts should be independent. Yes, it says, section 165, 4. It basically says organs of state, through legislative and other measures, must assist and protect to ensure the following. It is very important for who you are: independence, impartiality, dignity, accessibility, and effectiveness of the courts. It's an abuse of the courts for an institution with such weighty constitutional responsibilities to come with dirty hands before it, to say, yes, we have actually violated the person's rights, but we still want to use you as an institution of law to prosecute, to conduct a prosecution. That's the simplest understanding of what an abuse of process entails. The NPA wants to use the courts in order to continue abusing the rights of Mr. Zuma, and the courts should not allow it. And that would be a just and equitable remedy in the circumstances. And then And then I just want to also deal with why we believe that the court has to grant this remedy of a permanent stay. It's simply to prevent the abuse. And it's not just to prevent the abuse of Mr. Zuma. It is to prevent the NPA from abusing the powers that they have, and to prevent the court from being abused. Because the court that finally sits in this matter will have to grapple with all these issues that are being debated in this court. This is why you honorable justices, this is a judgment from the Supreme Court of Appeal, and it's repeated in many other judgments. It's judgment of Zuma versus National Director of Public Prosecution, 2009, Volume 1 SA, and it's in paragraph 68 that I wish to refer your lordships to, and your ladyship.
Paragraph?
It's paragraph 69.
69. Okay, yes. What other?
And I start off, it says, it is important to note that in the two applications now before me, the applicants do not challenge the constitutionality of the relevant statutory provisions. This is perhaps unsurprising in view of the fact that this court...
Which
citation? It was 2009,
2009,
Volume 2, SA 277 SCA.
Can I read it again?
Yes, you just...
2009,
Yes.
Volume 1, SA 1. And this is a constitutional court judgment. And this is a judgment of former Chief Justice Langa.
Thank you.
Yes.
Sorry.
And this is what anyway it says, and this you would consider binding on you, because it's a judgment of the Constitutional Court. It says that this is perhaps unsurprising in view of the fact that this court, in investigating directorate, and it cites the case there, unanimously held that Section 29(5) of the Act was not unconstitutional with the Constitution. Now, this is the important part. The decision explained the duty of courts imposed by Section 39(2) of the Constitution. Firstly, to interpret legislation so far as its language will allow, so as to promote the spirit, purpose, and objects of the Bill of Rights, before determining whether the legislation unjustifiably violates a fundamental right. It's the supreme duty of the court to consciously choose the side of that protects the constitutional rights of an individual, not the abuse that a state institution commits. There is no room to condone to have judicial condonation for the conduct of the NPA. But you are required, in terms of Section 39, to choose the side of constitutional rights. That's the decisive break that my learned leader spoke about. That's the shift in the legal philosophy that we would like you to move to, or that you are enjoined to move to. That you ought not to allow a prosecutor who is not able to explain this kind of conduct to stand before you and ask for a right to prosecute an accused person. When they have violated someone's rights, you ought to refuse. And you ought to rely, as I said, on the doctrine of abuse of power. You also have to rely on the doctrine of clean hands. Only somebody with clean hands. And the NPA is expected to be here in court with clean hands, not the kind of hands that this NPA has in respect of this particular prosecution. So you'll see, honorable justices, that when the Constitution has an intolerance for abuse of power. And it requires institutions to operate on the basis that they have a duty to protect constitutional rights. So what it essentially means is that the NPA itself has a duty to protect constitutional rights. It has a supreme duty to handle and manage the prosecution of Mr. Zuma. It doesn't matter what they think of him. They have a duty to hold his prosecution with dignity. That's a duty that they must, and without reservation, carry out. Now, I did say that I would say something about Mr. Trencroft. As you know, Mr. Trencroft gave a lecture soon after the termination of the prosecution of the NPA, the prosecution of the decision to prosecute Mr. Zuma. He was invited to go and give a lecture at a university, and he did. Mr. Down was present, and he got very good accolades from Mr. Trencroft, that he was the hero of the moment and he was the hero of this prosecution. But look at what he says. It's in volumes 14, and I can give you the page, but that lecture is very telling. One of the most senior advocates of our country went public and criticized the NPA and said they are wrong. They are completely wrong to have done this. He didn't end there. He then called on all lawyers to stand and speak against the abuse that the NPA had committed, against the grave abuse that the NPA had committed. He was not happy with that decision. He was an activist in as far as that case was concerned. He went and told the public to stand up. He said the NGOs must stand up because the NPA had committed a grave error. Today or tomorrow or today, whenever they speak, he will say something perhaps quite different. Because from what we've read in the papers, he will say that the NPA has not done anything wrong. But there he was talking and saying the NPA has done something bad.
On termination.
On the termination.
The procedure.
Yes, can I refer your ladyship to the lecture?
No, I understand
so
it, but where I was getting confused is that he's going to say something different. But I just wanted to understand that it was in the context.
So what she's trying to say is that the termination of the prosecution was wrong by the NPA. That's
what he was criticizing.
Yes,
He was criticizing that decision.
Yes, I accept what you say, my lady. But what I'm saying is that when the NPA presents the case today, whenever they do, they are going to say, they are not going to say the NPA violated the rights of Mr. Zuma. They deny that. They are not going to say that the NPA committed grave constitutional injustice. They stabbed constitutional process in the heart, because what the NPA did was to take decisions that, even as I say, one of the most respected senior counsel of this country went public and he spoke and he invited the public to stand up against the NPA for what they'd done. And he itemized exactly what wrong they'd done. But he will turn around and come and say, the NPA has got the constitutional credibility to prosecute a man who was subject to that abuse. And the lecture says what it says. But one thing that was astonishing about that lecture, as is with what the Supreme Court of Appeal, the judgment of Justice Nafta did, is that not once do they look at this violation of constitutional process by the NPA and then look at the impact it has on the person sitting on the other side. So when Mr. Trencroft spoke about the NPA and how badly it had behaved, he doesn't say, Mr. Zuma's rights have been violated. So the Supreme Court of Appeal doesn't say so. The Supreme Court of Appeal, all its concern was to focus on this violated constitutional process. But they don't look at what is the impact of that violation on the rights of the person against whom this constitutional process has been violated. And that's what that's what this court is going to be looking at. What are the implications of this constitutional violation that we've been talking about.
Mr. Masiko, I just want to be certain that I understand your submission correctly. So regarding the public lecture about the decision of Advocate Michel, you're saying that at that specific lecture, it was Mr. Trengove, in fact, saying that the National Prosecuting Authority was wrong. Not the individual employed, but it is the National Prosecuting Authority.
Yes, because I don't think he was calling for the public to have anything to do with Mshe as an individual. I think that would have been wrong. I think he was correctly calling for the NPA. So Honorable Court will no doubt catalogue all the transgressions that the NPA committed having regards to what the law says about the NPA. And it is very important for the judicial eyes to focus on extracting an answer from the NPA on why it believes it has the credibility to stand before it to ask for the prosecution of Mr. Zuma. And that is a point which we will not surrender. So you've been told what these violations are. The courts have told you, including the judgment of NAFSA, Justice NAFSA. Justice Nicholson has told you. Justice Msimanga has told you. So with judges, we've said, no, this is not right. And then we've got the NPA itself saying it is not right what happened. That is what. So this application is not as the NPA would like to have it. It's not an attack on the integrity of the NPA, but it's a defense of the rights of Mr. Zuma. It is not an attack on democracy. It is actually a defense of democracy. It is not an attack. It is not a game, as they would like to suggest, this idea that we are engaged in some game called Stalingrad with a view to avoiding prosecution. 4 or 5 times the NPA had an opportunity to charge Zuma, they didn't do it. On their own, they didn't do it. Muga didn't do it. Mshe decided to terminate it because he sent the NPA unprepared to start the prosecution.
Can I just ask you this, Mr. Masu? What aspect of Nicholson's judgment do you consider as a game changer?
Which
aspects of Nicholson's judgment do you consider as a game changer?
Game changer?
Yes.
No, I use no word like that.
No, I'm using it.
In that judgment, you'll find criticisms,
yes,
legitimate criticisms of the NPA,
yes,
and what they've done. That was wrong.
You see why I use the word game changer, because the SCA found otherwise.
No, it's true that the NPA...
Yes, that's why I'm asking you the question.
It's true that the SCA did find differently.
So what lines can you then place on the Nicholson's judgment in light of the findings of the SCA?
You have to yourselves look at what it is that courts have said, whether you agree with the courts or not. So there will be judgments that are in favor of the NPA. All I'm saying is look at what judges have said. Judges who said in your position what they said when they looked at the NPA. They may have been wrong and overturned by another court, but that does not take away what the courts, even in the lower courts, viewed that conduct.
Yes, I'm trying to get from you that which you consider as of assistance to your to Mr. Zuma's case, insofar as the judgment of Nicholson is concerned, in light of the findings of the SCA. That's why I'm asking you the question.
this is what in paragraph 78, Justice Nicholson says. He says in his judgment, he says,
Yes.
from time immemorial, the executive has cherished the notion of usurping the independent function of the prosecuting authority and directing criminal prosecutions at its political opponents. That was so under the apartheid government. That it was so under the apartheid government is manifest in the catalogue of prosecution. From treason trial to the early 60s, to the plethora of prosecutions thereafter under the Terrorism Act, bear witness to the stratagem. Many activists languished for many years behind bars as a result of prosecution at the instance. Even Justice Arams wouldn't overturn that part, because it's true. And then if you look at paragraph 80, where Nicholson says, section 108(1) of the interim constitution repeated the notion of an absence of political interference when it vested Attorney General with the power to institute prosecutions on behalf of the state. There are numerous
Yes.
paragraphs on the judgment, Justice Mnguni, that I could refer to, but the point that I really make.
So if I follow your argument, I ask this question from Mr. Kakane. Once we find that there was a constitutional violation, we shouldn't look at the balancing act.
No. That is not my submission.
Okay.
My submission was specific. It was that when you find constitutional that there was a
Yes.
constitutional violation,
We
you
still
must
have-
then look for an order that is just and equitable as you are required in section 174 of the Constitution.
So we must first
72, I beg your pardon.
call for the balancing act and then come up with the
No, it's the other way around.
Okay.
You start off by finding that there's been a violation.
Yes, we've already gone that
Right,
stage.
and then you
And
go
the
to the
next
balancing
stage-
act. You're looking
Yes,
for a just and
yes,
equitable remedy.
yes.
And then you say, if we accept that the NPA has behaved badly,
Yes.
in the scales of justice,
Yes.
equity, taking into account our supreme duty to protect constitutional rights, what appropriate remedy do we need to grant in this matter? We say you should grant a permanent stay and not allow the prosecution to proceed. And we say that would be a just and equitable order, taking into account the judicial comments that have the NPA cites many cases that Mr. Zuma has been involved in together with the NPA. But finally, I probably will be chastised by my leader for saying this, but I'll say it anyway, and I'll apologize to him after that. But finally, it's a very worrying development that you have to deal with. And if you don't deal with it, as my learned leader said, it conveys to the public that the NPA is not accountable. It can make other people account, it can prosecute people, it can violate people's rights, then take them to court. That's classical apartheid prosecution. Dangerous weapons in the hands of the state, where they can simply torture someone out of his mind. They know the person has been tortured, but they nonetheless still want to prosecute him. Let's break away from that and highlight the importance of our constitutional state, which has constitutional rights that protects individuals. My lord, my ladies, there has to be consequences for a prosecutorial misconduct. Those consequences can either be the NPA itself adopting internal measures of ensuring that prosecutors who do not comply with its laws are dealt with. In this case, we know nobody who has been dealt with as a result of how this prosecution has been managed. No one has accounted for it. We stand before this court today to ask that you make the NPA account for what they have done. If we say there is a possibility of a constitutional crisis, it's not an alarmist position. You can't flip-flop like this when you've got such power, and when you are governed by a constitution. You've got to be stopped in your tracks when you deviate from the constitutional standard that governs and that guides you. And that is what we say should the courts should guard against. I did say the last, but I now want to ask for the last submission that I want to make relating to what the courts say in Corruption Watch. Because in a way we're dealing with a serious form of prosecutorial corruption, corruption of state power in pursuit of a single individual. If you beg leave, I beg your pardon. Can I just sort out my, yeah. Oh. So in the economic freedom, sorry, I meant the Corruption Watch. But my technology has failed me, but let me just make the submission. In Corruption Watch, and you'll find the paragraphs in paragraph 18 to 22, there the Constitutional Court again sets out in commendable detail and with very crisp, with clarity, what the duties of a court are. The court ought not to close its eyes to a clear injustice perpetrated by an organ of state, not under this constitution that we've dealt with in detail. Thank you. I do have the quotation. It says, this is what the Constitutional Court says. It says, in the recent case of Corruption Watch versus the President, the Constitutional Court has underscored the sacrosanctity of prosecutorial independence. The court said the following: the importance of the office of the NDPP in the administration of justice is understood and amplified by no less an instrument than the Constitution itself. So you'll see when you read through that they pretty much tell us how important it is for the court not to close its eyes when allegations are made that this NPA before you today is dripping in its hands with the violation of constitutional rights, and you should not be quiet as to use Mr. Trenkoff's as call. This is a case in which one must speak, but this time speak for the rights of the people that are likely to be affected by prosecutorial misconduct or acts of misconduct. Speak for those rights. And this is what this side of the table are speaking on behalf of. Those are my submissions on the part I needed to deal with.
Yes, thank you.
Can
you start tomorrow at 9:30?
I would have begged the court's indulgence
Yes.
to take the 10 minutes that are available just to describe what our case is about and what it's not about, with the Lordship and your Ladyship's permission.
Sorry, can I just interject?
Okay.
I have not dealt with the striking out
Yes,
application,
we understand.
but I will respond when that has been dealt with
No,
by
that's
the
fine.
MPA.
It's okay. You have 5 minutes. You want to?
Perhaps the 5 minutes I'll take in the following way. May the court have regard to pages 1 and 2 of the record and our bundle of authorities, page 2 of volume 1. Because with those 2 pages, 2.5 pages, I will describe, before we go to sleep tonight, what it is that my client seeks and on what basis it seeks it. Tomorrow morning we'll start, I understand, at 9:30, and we will produce what I call a note on oral argument to make it easier so that the flow of the argument will go faster. On page 1 of our notice of motion, the court will see paragraph 1, 2 and 3 on the next page, and they are divided into 2 sets of relief. And also, the court could also have regard to page 2 of our bundle of authorities, volume 1. So it's volume 1 of our pleadings and volume 1 of our bundle of authorities. In paragraphs 1 and 2, there is an attack. There's paragraphs 1 and 2 of our notice of motion. There is an attack on the reinstitution of our client by NDPP Abrams. Paragraph 3 is our permanent stay application, which is in a similar way that which you've heard today from Mr. Sikakani and Mr. Masuku. But we go further because our clients are to be regarded as an add-on, and the prosecutorial misconduct we would submit is of a different kind, but certainly a kind that if ever there was to be a case of a permanent stay, it would be in our client's favour. If I may take the court to page 2 of our bundle of authorities, one sees an extract from the Constitution, and it's section 172(1) of the Constitution. Let me just highlight that paragraphs 1 and 2 of the notice of motion, which I've explained, relate to the unlawfulness by NDPP Abrams, sought under. I'll wait for your ladyship, because it's quite important to explain the genesis and the underpinning, the objective underpinning of the case.
The interpretation of section 22.
It's page 2 of my bundle of authorities. We submit that this court is exercising its power from start to finish in our case under section 172(1) of the Constitution. Because this is clearly a constitutional matter within this court's power. Obviously, when the prosecution exercise a power to prosecute or not to prosecute, and there's a challenge to it, that is a constitutional matter within this court's power. Then, what the Constitution demands is there are 2 items, 2 remedial issues. The one is A, it must do something, the court, and B, it may do another thing. What it must do is it must declare any law, and in our case it's conduct that we're challenging in paragraphs 1 and 2 of our notice of motion. That's Mr. Abrams' decision to reinstitute the prosecution against us. That's his conduct. And we submit that Mr. Abrams' conduct in making the reinstitution decision was unlawful, inconsistent with the Constitution, and we therefore submit that if the court is with us, there is no discretion. You must make the declaration of his conduct being bad. That's become a trite proposition, starting off with Darwood in 1999, all the way through to Nkandla and all the cases where the Constitution would have emphasized over and over and over, if there is conduct that is inconsistent with the Constitution, the court must declare that. And that's what we ask for. B, is our prayer 3. And that is where this court has a wide discretion to make any order that is just and equitable. Any order. And the courts have said it must be appropriate in Hoffman versus South African Airways. And the court looks at all the circumstances. Is there a violation of right? And we've heard the whole day about this balancing exercise that the court must engage in. And then when it exercises its balancing, whatever the word is, it's been a long day for all of it, but it sits on this balance. And then it comes to a conclusion and it does what's just and equitable. And we've borrowed the wording in paragraph 1 of the Van Heerden judgment, which is on page 261 of our bundle. Sorry.
Mr. Katz, it is a long day.
Yeah.
And I think we've been sitting here since very early, and tomorrow morning we will start even more earlier. But in order for, since you are giving out homework, let's start off by the fact that if you want to argue the conduct that is inconsistent, then perhaps also you can assume in our favor that we have read all the papers, and we've read also your written hits. But then perhaps what you then consider is the submissions regarding that conduct vis-a-vis what the National Prosecuting Authority Act says, and whether there is really conduct that is inconsistent. Because that's the first hurdle to get over, and perhaps that should be clearly spelled out to us. That conduct of Mr. Abrams, according to your submissions.
Can it be done tomorrow?
Yes, and that you can then do tomorrow, but overnight you can think about those submissions you want to make.
Yes.
But your entire argument seems to be pegged on the interpretation of Section 22.9.
There are 3 parts to the argument.
Yes.
There are 3
But
parts
we will deal with them tomorrow.
Yes.
Don't worry.
Yes, that's just
we know
one part.
where to
That's
go
part.
to.
That's the little one, and then 2 others: the prosecution policy and the rationality.
We know what
I do want to make this last submission before we go to sleep.
You really want us to bring this case now?
I have no doubt that you will be doing so.
No, we're
I've been having nightmares about it for so long, but anyway, a dream nightmare. The point is this: our paragraph 3 order, the permanent stay, just and equal relief, is not dependent upon the court granting paragraphs 1 and 2. So even if the court disagrees with our argument that we are not entitled to paragraphs 1 and 2 because Abrams did a fine job, we still argue that paragraph 3 is ours to be taken. And to the extent that the court wishes, I'll give the court authority tomorrow. It's Van der Merwe versus Minister of Safety and Security. Constitutional courts say a just and equitable B order is not dependent upon an A order being granted. I'll give that authority tomorrow.
Don't worry, we'll take care of it. Thank you. Thank you. We start at 9:30 tomorrow.
No, just wait your car.
There we go.
Is that minus 24? Yeah.